Welcome to the Explainer. So, I want you to imagine trying to write the operating system for a nation of over 1 billion people, a place with staggering linguistic diversity, massive geographical differences, and just deep, deep historical complexities, right? Well, that is exactly what the framers of the Indian Constitution managed to do. Today, we're diving into the world's longest written national constitution, but we aren't just looking at the main text. We're focusing on its secret weapons, the schedules. These are the appendices right at the very end of the document that literally do all the heavy lifting to keep this incredible democratic balancing act from falling apart. Now, when the Indian Constitution first kicked off back in 1950, it started with 395 articles and just 8 schedules. But, as the nation grew and its challenges naturally evolved, so did its supreme law. Today, it's expanded to a massive 470 articles and 12 schedules. And it's these 12 schedules where the lofty abstract ideals of democracy actually meet the gritty, complicated reality of everyday governance. Okay, let's look at our roadmap for today. We're going to cover 1. Decoding India's supreme law. 2. Dividing power in the 7th schedule. 3. Protecting languages via the 8th schedule. 4. Tribal autonomy looking at the 5th versus 6th schedule. 5. The vault of the 9th schedule. And finally 6. Stopping defections with the 10th schedule.
Let's jump right into Section 1, Decoding India's Supreme Law, the evolution of a monumental document. So the Constitution was formally adopted in 1950, right after independence. And the framers, led by figures like Dr. B.R. Ambedkar, they really had a monumental task on their hands. They had to unify a massive, incredibly diverse nation emerging from colonial rule, all while dealing with the integration of princely states and immense social challenges. To handle all of that, the document has ballooned to 470 articles today. Now, you might be wondering, why on earth do we need schedules if we already have 470 articles? Well, think of it this way. If the articles are the main program of the operating system, the schedules are the specialized databases it calls upon. They handle the highly specific, complex, and frankly constantly changing details, things like lists of states, salaries, or recognized languages, so that the main constitutional text doesn't just become impossibly cluttered.
Moving right along to Section 2, Dividing Power, the 7th Schedule. Federalism versus centralization. Think about this. How do you give a central government enough power to keep a vast country united, while also giving states enough power to govern their unique local realities so the whole thing doesn't just fracture? The 7th Schedule solves this massive problem by breaking power down into 3 distinct lists. The Union list contains 99 big picture items. Well, actually, scratch that. It's more like macro-level survival stuff, like defense, foreign affairs, and railways. That's where only the central parliament can make laws. Then, the state list gives regional governments exclusive control over 61 local issues, like police, public health, and agriculture. And finally, there's the concurrent list with 52 items, like education and criminal law, where both the union and the states can legislate. If there's a clash on a concurrent item, the union law generally wins out. It's an incredibly precise, structured division of responsibilities. Next up, Section 3, Protecting Languages, the 8th Schedule. Unity through diversity. Language is just so deeply tied to identity, and in a country like India, balancing a unified national administration with the rich, historical, linguistic diversity of its citizens is, it's incredibly delicate. This schedule is basically the Constitution's primary tool for that balancing act. Back in 1950, it started with 14 original languages, including Hindi, Bengali, Tamil, and Urdu, but look at how dynamically it's evolved. In 1967, the 21st Amendment added Sindhi. Fast forward to 1992, Konkani, Manipuri, and Nepali were brought in. And in 2003, 4 more were added: Bodo, Dogri, Santali, and Mathili. So today we're up to 22 recognized languages. Being on this list is a big deal. It guarantees administrative recognition and actual government support for development and cultural preservation. But get this, what is truly staggering is the sheer scale of the ongoing pressure. Right now, there are demands for 38 more languages to be added to the 8th Schedule. We're talking languages like Bhojpuri, English, and Rajasthani. It perfectly captures this continuous tension. On one hand, communities absolutely want their cultural heritage preserved and recognized. But on the other hand, recognizing too many languages can severely complicate everyday governance and translation. It's a tough balance, for sure. Section 4. Tribal autonomy, 5th versus 6th, protecting culture and custom. Let's explore how the Constitution protects indigenous and tribal populations. The 5th and 6th schedules represent a completely fascinating contrast in how the state approaches tribal autonomy. The absolutely crucial point here is the difference in approach.
The fifth schedule covers tribal areas in 10 states across central and peninsular India. It's highly protective, but it relies heavily on the governor's regulatory powers and a purely advisory body called the Tribes Advisory Council. Basically, they can advise, but they don't have real legislative teeth. Contrast that with the sixth schedule, which applies specifically to 4 northeastern states: Assam, Meghalaya, Tripura, and Mizoram. Instead of just handing out advice, it grants active autonomy by establishing self-governing autonomous district councils. Let's look a little closer at those autonomous district councils under the sixth schedule, because they are effectively mini constitutions. These councils aren't just symbolic. They wield real, tangible power. They can actually make laws regarding land and forest management. They regulate sensitive social customs like inheritance and marriage. They can even assess and collect land taxes. And incredibly, they can constitute village courts to exercise judicial functions over their regions. I mean, it's a massive devolution of legislative, executive, and judicial power to preserve a unique way of life. On to Section 5, the Vault, the ninth schedule. Legislative power versus judicial review. Welcome to what we can neutrally describe as the ultimate constitutional vault. This schedule represents the profound tension between the power of the legislature to make laws and the power of the courts to review them. It was actually created by the very first amendment back in 1951. Originally, the government just needed a way to protect vital agrarian reforms, like abolishing the zamindari estate system, from being constantly challenged in court for violating fundamental property rights. So they created Article 31B, which allowed Parliament to place laws safely inside this ninth schedule vault. Once inside, these laws were totally shielded and couldn't be struck down by courts for violating fundamental rights. But, over the decades, it grew exponentially. It went from just 13 laws to 284 statutes, and many of them had absolutely nothing to do with agrarian reform. And that brings us to a historic legal showdown. The Supreme Court eventually had to step in to restore the balance. In the landmark 2007 I.R. Coelho case, a 9-judge bench delivered a sweeping ruling. They stated impartially that while Parliament can absolutely amend the Constitution, it simply doesn't have absolute authority to hide laws from the courts forever. The ruling meant any law placed in the ninth schedule after April 24, 1973 is now subject to judicial review if it violates the Constitution's basic structure, core things like equality and liberty. It basically ensured that initiatives for social justice couldn't entirely obliterate the foundational guarantees of fundamental rights. Finally, Section 6, Stopping Defections, the 10th schedule, Stability versus Conscience. This final piece of our balancing act was added in 1985 to solve a massive crisis of stability. Politicians were constantly switching parties after being elected, lured by offers of ministerial posts or other perks, which naturally led to government collapse and chaos. To stop this, the 10th schedule introduced strict rules enforcing party discipline. Basically, a member of parliament or state assembly can be disqualified if they voluntarily give up their party membership or if they vote, or literally even abstain from voting, contrary to the directions issued by their party leadership, which is known as a whip. Furthermore, an independent member cannot join a political party after being elected, and nominated members only have a 6-month window to join a party. If these rules are broken, the presiding officer of the House is the ultimate deciding authority to disqualify them. But there is a major exception to this rule. The law explicitly differentiates between an individual defection and a party merger. If at least 2/3, so 66.6%, of a political party's legislators agree to merge with another party, the law protects them. In this specific scenario, neither the members who decide to leave and join the new party, nor the ones who choose to stay behind, will face disqualification. Which brings us to a really fascinating, frankly provocative question to conclude this explainer. Does the anti-defection law sacrifice a legislator's conscience for government stability? By forcing elected representatives to essentially always vote exactly as their party leadership dictates, it definitely creates stable governments. But it potentially breaks that crucial link between the legislator and the voters who actually elected them. They can't vote their conscience without risking their job. It's the ultimate trade-off in the balancing act of a massive democracy. Thank you so much for joining me to decode the operating system of the Indian Constitution. I really hope this gives you a completely new perspective on how power, identity, and stability are managed on a billion-person scale.